This is a reproduction of a live workshop that I gave on September 6th at the Small Business Expo in Los Angeles. And at the time of this recording, I will be giving it the Small Business Expo in Las Vegas on September 21st. Now, let's move on. Okay, so what are we going to be talking about here? This workshop that I'm reproducing is going to be in two parts. Actually, that looks like four, but I mean two. How to resolve a business dispute on your own, and if you can't handle it on your own, what can you do? And this is really important. But before we get on, why don't I tell you who I am? I'm Howard Klein. I currently serve as a mediator and arbitrator, and I've been a California licensed attorney since 1976. Actually, this reproduction is being streamed live at the time on my birthday. I've handled thousands of lawsuits. Well, I'm not sure how many thousands. I lost count a long time ago, involving general business, commercial real estate, employment, and personal injury matters. I've actually been an advocate for a supermarket chain in arbitrations with various unions. I've also served as general counsel for 4 different companies over the last 46 plus years. So why don't we move on to the actual, what we're going to be talking about. So the first question is, how do you resolve your own disputes? And I approached this from a number of different ways, but as a mediator, we work very hard to get the parties to minimize their emotional responses so that they can be less reactionary. Now, when I talk about being less reactionary, this is easier said than done. I've been working my whole life trying to be less reactionary, more like my father and less like my mother. This is an important thing for me to be able to handle things properly. The more emotional I am, the less effective I am. One of the other things that I'd like for people to understand, whether as a mediator or as an attorney where I represent parties, is consider all costs, including time and your focus. This is so very important. Yes, I know when I talk to my clients, I often suggest to them, avoid litigation at all costs. I know you can't avoid it sometimes, but sometimes if you plan in advance, you can do some mediation and you can do arbitration, which should be much less expensive. When I'm talking about costs, not just attorney's fees, I'm talking about your time as a person involved in the dispute and your focus. If you can't focus, you can't concentrate on moving forward and from a business perspective, making more money. It detracts from your ability to move forward and make more money. This is terribly damaging, and people really don't pay attention. And as I like to tell most of my clients, at some point in time, you're going to really not be happy about continuing to write checks to me. Another factor that I pay attention to for both clients and parties in a mediation is consider what you know and what you don't know. I actually had a mediation a few months back where it was a landlord commercial. Actually, I don't recall if it was commercial, but it was a landlord-tenant eviction. The landlord was represented by a property manager who had indicated that they had been to court hundreds of times handling evictions. The tenant had indicated that no, they have never been a tenant or defendant in an eviction matter. That's good for them. Unfortunately, they also said that they were absolutely certain that the court's going to rule in their favor. And if you've got any experience in court, you're going to know that you never know what's going to happen. You never know how a judge is going to rule, and you never know how a jury's going to rule. And these are important considerations. So if you don't have a lot of experience, you need to consult with someone who does have more experience. The experience factor is just so very important. And before you run in headlong into resolving a dispute, you need to know what you know and what you don't know. So, next. Now, I really hate watching videos that tell you what you should do and what you shouldn't do. So when I tell you, you need to be less emotional, I have some tricks on how you can do it. And these are some of the tricks that I have read in books and tricks that I have taken and done myself over the years. So let's talk about a keystone habit. All right. And this is, again, easier said than done. But trying to react unemotionally is very difficult. And the only way that you can do it is to try to focus on when you feel that anger welling up or that reaction. Try to focus on one thing. That's a keystone habit. And a keystone habit is a habit after which other habits follow. They can transform you. So, for example, a keystone habit would be not eating sugar if you're trying to lose weight. Another keystone, it's not that easy, and we're going to be talking about practicing. But if you can just focus on that, cut that out. Or if you love French fries, cut out the French fries. And don't worry about whether or not, you made a mistake and you had French fries today, or you gave in. You just got to keep at it. And Charles Duhigg, and this is a book that I recommend that you read, he correlates keystone habits with other good habits, and they can spark a chain reaction that help other habits take hold. I'd like to talk about a habit. I don't know if anybody out here has tried to quit smoking, and when I did smoke, I used to tell people quitting smoking is very easy. I've done it 1,000 times, which kind of shows how difficult it is to quit. Well, what happened was I started dating my wife over 30 years ago, and I couldn't smoke in the house. The only place I could smoke in was the car. So I would have my cigarettes in the car. I'd drive to work, and invariably I go, I want to quit next week. On Monday, I'll quit. Of course, Monday comes around, the cigarettes are still in the car, and I'm halfway to work. And of course, between my fingers is a lit cigarette. And I go, next Monday, I'll go ahead and quit. Where I started a keystone habit was 1, not buying cigarettes, and 2, not putting them in the car. And then what happened without even knowing it, and that took a while, but without even knowing it, I stopped smoking. And I haven't smoked now for over 26 years, almost 27 years. A keystone habit is the least common denominator in the chain of habits. If anybody plays golf, I think that the first thing you need to learn is how to grip the club. Because nothing else starts until you grip the club. And gripping the club correctly. And so if you start lessons, they will start you out with how to grip the club. And then you just keep on practicing that and practicing that and practicing that until you don't even have to think about it. And then you can move to something else, how to address the ball, etc. One of the worst things about learning how to play golf is trying to accomplish all the things and create everything or clean up and change all of your bad habits. That's not going to happen. You got to start with one thing at a time. So let's move on now. Here are my top recommendations for keystone habits, but it really depends upon you. What you want to accomplish and how you go about doing it. For me, back in college, I took a yoga class. And the first thing that they told us to do was sit in the lotus position, which back then I could actually do. Close your eyes and breathe through your nose and focus on the tip of your nose. And they said what will happen is the tip of your nose will start warming up. And in reality, it did. And when you can focus on one thing alone, everything else kind of goes out of your head. So I like to take a breath. When I have trouble falling back to sleep, I'll close my eyes and I'll breathe through my nose and I'll focus on the tip of my nose and I'll stop thinking about all the 1,000 other things that are going through my mind, and I stand a really good chance of going back to sleep. And that's really good. Another keystone habit is regular exercise. I used to do that on a regular basis. Now, as I've gotten older, it's become more and more difficult to do. So a lot of my focus on my keystone habit is eating correctly. And I have another keystone habit. Because I have type 2 diabetes, I've gotten into the habit of checking my blood sugar at least 2 to 3 times a day. And I find that habit gives me something to answer to. And I tend to eat much less sugar. And I've actually brought my blood sugar down, my A1C, from like 11 something or another to 5.8 without insulin. And that worked really well. Meditation is another keystone habit, and that really has to do with what I was talking about in yoga. Meditation is more than just stretching and physical exercise. It's giving you the ability to focus correctly. Let me go back for a second to taking a breath. This is something that I have tried to train some of my clients when I've acted as an attorney, and they would have a deposition. And a deposition is where the other attorney has the opportunity to ask my client questions. So before we go through their deposition, I actually train them. I spend a bunch of time training them. And one of the things that I've told them to do, because people have a tendency to quickly give an answer and then say something that's not entirely accurate. And I don't mean that they're lying. It's just sometimes you think of something and you're thinking that what you believe happened actually happened. And that doesn't work very well. So what I tell my clients to do is when you hear the question, take a deep breath. And that does two things. One thing, it gives them an opportunity to think about the question that was being asked. It gives them an opportunity to relax because they take a deep breath, and it gives me an opportunity to make an objection if I can do that. Then I tell them, after you exhale, and if I haven't objected, repeat the question to make sure it's accurate. By the time they're done with that, then they can give an accurate answer. And breathing is just, well, other than the fact that it's essential, the type of breathing that I'm talking about is extremely important to be less reactionary. And being reactionary just kind of inflames everybody and starts putting people in unretractable positions. So let's move on now. This is a upside down pyramid that I've created. And I like to use it to give an example of how, how this proceeds. So first of all, I'd like to start, and I put it at the bottom, but it is also essential, is preparing yourself. All right. You then take a breath. So if you know you're going into a negotiation or you have a dispute, be prepared. Know what you're going to say as much as you can so that you're not guessing. Take a breath when you hear somebody. Then the other thing is go ahead and it gives yourself time, as I said, and it gives you an opportunity to consider how to respond. It allows you to respond properly, and I'm having trouble reading. Oh, that's not good. Wrong glasses. There we go. Consider the other person's perspective while taking into account your own needs. Now, in this video, I'm not going to be talking excuse me. I'm not going to be talking that much about considering other people's perspectives and sympathy and empathy. That's a topic for another video. But this gives you, it's really important to think about the other person's perspective. So when you hear things, if you take that breath and you train yourself, you can go, okay, let me understand. Excuse me. Let me understand what their perspective is. Let me understand what they're looking for and what they're trying to accomplish. And rather than get angry at them, understand it. And at the same time, you shouldn't just roll over and give in. What you need to do is consider it and then consider your needs. And then if you understand them and you also understand your own needs and what you're trying to accomplish, then what you can do is you can then start working towards a resolution. Now, I love this video. Henny Youngman, I think it was Henny Youngman, or Yasha Heifetz, who was a famous violinist. They tell a joke, or I think someone asked Yasha Heifetz, how do you get to Carnegie Hall, which, if you're not familiar, is a famous, well-known venue for shows and orchestras and symphonies, etc. And he would say, practice, practice, practice. So when I give you these little hints, meditating, exercising, you need, one, patience, and two, you really need to practice it. You need to understand that you're going to fail many times before it starts sinking in and becomes a good habit. Case in point, I've been doing live radio online since 2010. And originally I had a producer and I had other people helping me. We used to debrief after every show and talk about what I did right, what I did wrong, what I could do better. And that's a great, habit that we got into to begin with. But that's not the habit that I'm talking about. I would also then go back and listen to the radio show. And initially I'm trying to think of the right word, outraged at some of the words that I said and how I said it. And here is a case in point. And you would think that someone as knowledgeable and articulate as me would be able to say this word differently. I used to say particularly rather than saying particularly. And every time I would hear myself say that, it drove me nuts. So what did I do? With that word, in other words, if I got in the car with my wife and I started talking with her, I would purposely say the word particularly. It still feels a little uncomfortable, but I properly enunciate it. And I didn't do it at first, but I kept on doing it. I kept on doing it. And now when I'm about to say the word particularly, I think my brain automatically says particularly. The other habit that I have, and if you've ever done videos or podcasts or been on the radio, you recognize that you say a lot of uhs and etc. That also takes a lot of practice. So I practiced so that if I was at various times, if I was talking with my wife or other people, I would focus on not saying, those pause words that in normal conversation, nobody pays much attention to, but you do if you're doing video and radio. Now there's AI that can cut out that kind of stuff. So it's repetition, and repetition forms patterns, and patterns define the future. My kids, I used to do live theater, and you would be shocked at how I rehearsed my lines. I was terrified about forgetting my lines. But I used to use a pearl quarter and play it back, and I'd go like 5 words at a time. And then I would repeat it until I had it without having to check what the word is. And then I would do the next 5 words. And then I'd do those 5 words until I didn't have to listen to the tape in order to remember those 5 words. And then I would go back to the first 5 words and add the second 5 words and do all 10 words until I got that straight. My kids, who are much younger, obviously, were able to remember everything immediately. Me, it took work. It took lots of work. And I created patterns. And a lot of my work that I do now are based upon patterns that I've created. So now let's move on. What do you do if you can't resolve your business dispute on your own? Conflict. All right. And let me step back a second. And I'll probably do another video on that, is conflict is not a bad thing. Conflict it happens every day, all day long, whether it's business or personal. It's how you deal with the conflict, which is the important thing. And that's what we're trying to do here. So in this video, you might ask, why is Howard trying to tell me how to resolve my own dispute? He's a mediator and arbitrator. You would expect that he would want us to hire him. You know what? If you could pick up one habit and improve your life, you're still going to have disputes that you can't handle on your own. I'm not worried about how much money I can make. I don't need the short term. What I need is informed parties who know how to deal with the dispute and use my assistance, either as an arbitrator or mediator. Now, who do you go to if you have a problem that you can't resolve? Well, you can go to clergy. I think clergy is an excellent place to start, and they should be trained to help you resolve and think out your own issues. A lawyer. I'm a lawyer. Lawyers fight for you. Lawyers also cost money. Clergy, well, if you don't have to make a donation, clergy doesn't cost you money. You can go to a mediator and arbitrator. If you go to a mediator and arbitrator, what you need to do and understand is it takes 2 parties to use a mediator and arbitrator. You can't go to the mediator and arbitrator and say, give me some advice. All right, the mediator and or arbitrator can help you. And again, that costs money, but if you can avoid a lawsuit, that probably is a good thing. It'll be faster, which I'll explain later, and it'll be less expensive in most instances. Who are the other professionals? Well, you can go to a coach, you can go to a therapist. A therapist should be trained to help you think out your own problems, which is a lot of what we do as a mediator. Or you can go to a friend. All right? Any of these could be helpful to you. All right? So let's move on. Okay. I'm switching here. All right, let's talk about the benefits of mediation or arbitration. Let's start with one. Mediation can save you money if you resolve early. All right, you don't have to resolve early, but if you do resolve it early, that's a great thing. The agreement is made by the parties. Thus, it's more durable, meaning it's likely to last longer. That doesn't mean that everybody walks away totally happy, but considering the downside, they should be happier. Mediation is also private and confidential. There are no rules of evidence and there's no jury. All right. In other videos, I'll be talking about this more. Arbitration. Arbitration is usually faster than a lawsuit. There are occasions that it may not be. It really depends upon how parties agree on the process, but it usually is designed to go much faster. It's generally less expensive. Time is money, and also it is less expensive in terms of doing a lot of what we call discovery. It's often private and confidential. This is something where I said it often is. It depends upon the agreement or the rules. It is very limited discovery. And let me explain to you what discovery is. Discovery is, it can be used in arbitration, and usually in arbitration, depending upon the value of the amount in dispute, discovery may be limited or not limited. In any event, discovery, talking about it in the context of a lawsuit, is where each party is given an opportunity to ask the other party for all of their evidence, whether it be testimony, whether it be documents, whether it be any other information. And it's also an opportunity in litigation where you can ask by subpoena third parties to testify to support your case or to defeat the other party's case. Discovery is probably it's not probably, it tends to be the longest and most expensive part of a lawsuit. The parties in arbitration have some control over the rules and procedure. They can agree to their own rules. Where in a lawsuit, pretty much the court tells you what the rules are and how you have to follow it. And another opportunity is to go ahead and you don't have a jury trial. Now, for some people, that's really, really important. A landlord, if you can avoid it, you don't want to be in front of a jury. And the reason for that is a jury tends to relate much better to the tenant than they do a landlord. Far fewer jurors have been landlords. Okay, so let's talk about litigation as compared to mediation or arbitration. First of all, it's public, it's not private. Well, there are some limited exceptions where there is confidential information that the court can receive without it being disclosed to the public, but generally, if both parties are airing their dirty laundry, it's usually lengthy and more time-consuming than arbitration or mediation. That doesn't mean that mediation should necessarily be handled in one session. It can be handled in multiple sessions, but litigation, it's so time consuming. Let me give you an example. I'm winding down my law practice at the moment, but I have one matter that involves it's a lawsuit in which my client is suing another party. All right, this is not a complicated lawsuit. It's pretty simple. We go to, I think it was in August, we had a case management conference where the court then decides, okay, are we ready to set the trial? So I'm thinking maybe we could have trial in January of 2024. The case management conference is in August of 2023. That would have given me enough time to file whatever motions I need to file and finish my discovery. No, the court sets the trial for March of 2025. Well, okay, we don't have to focus on it immediately, but gosh, that's the court process. The courts are so far behind that even a simple matter that might be only a few hours in trial is set like a year and a half later and 2 years from the date that we originally filed the complaint. Let's talk about litigation. The parties have very limited control over the process. And the court strictly follows rules of evidence, and a jury, in many instances, is available. Now let's talk about the rules of evidence. In most instances in arbitration, the arbitrators tend not to strictly follow the rules of evidence. And I think that's a good thing because as an arbitrator, I can accept evidence in because it's not going to prejudice me, but I can weigh the evidence, meaning I could say, well, this is really good evidence or not. And that's up to me as the arbitrator to make that decision. So let's now move on. And if you like what you're hearing and you're watching this on YouTube, please subscribe. If you're watching this on Facebook or on LinkedIn, follow me. And I'd love to be in touch with you. Okay, so what's the difference between mediation and arbitration? And as a mediator, most of the non-lawyers who are in mediation, they really don't understand what the difference is. And I think this is a good opportunity to explain that. First of all, mediation is voluntary. All right? You need two parties to do it. It's generally faster than either arbitration or litigation. It involves an agreement made by the parties, not the mediator. Here it says not the arbitrator, but the parties make the agreement. All that we do as the mediators try to get you to, we control the process to try to get you to openly communicate. And it is private and confidential, right? And the parties usually agree to keep it private and confidential. And just about in every jurisdiction that I can think of, the mediator cannot testify in court as to whatever is discussed in mediation, and that's so that the parties can openly discuss matters without worrying about whether or not it's going to be used in court. Arbitration, like mediation, is also voluntary. It takes two parties to agree to it. In many instances, the arbitration provision is contained in an earlier agreement. Landlord-tenant may have an arbitration provision that all disputes must first be arbitrated. The arbitrator makes the decision or the ruling. And I like to tell people that if you don't settle it yourself, then I make the decision and somebody is likely to be unhappy. And that often motivates parties to kind of resolve things. It is often, in most instances, private and confidential, but that should be contained in the agreement. And the parties have some control over the rules and procedures. Consider mediation and arbitration that it can occur concurrently. And what I mean by that, in some jurisdictions allow an arbitrator to also act as a mediator and vice versa on the same matter. Some jurisdictions don't allow it. Even if I were in a jurisdiction that allowed it, I wouldn't do it because it's a different hat that you have to wear as the arbitrator and the mediator. And I have to be unbiased in all instances. So let's talk a little bit more about my focus during mediation or arbitration and what the difference is. Well, in both instances, I have to be unbiased. That means even if I have this micro bias and someone looks like someone that I don't like, or I don't like the way they talk, I've got to control myself. That has nothing to do with resolving a dispute. I do need to understand cultural differences to try to get the parties to communicate. I am non-judgmental, and I really am. I may in the back of my head think something, but it doesn't come out of me, and there's no way that I need to allow anybody to know that I have any preconceived notions. As a matter of fact, whenever I do have a preconceived notion, my assumption is that I'm wrong. All right? And I work from that. What I really focus on in mediation is to get better communication between the parties. And this goes back to one of the first things I said is being less emotional and less reactionary. In mediation, people take a position often like, I am not going to let the other side win. That's a position. All right, that's not really what their interest is. Their interest is, in a business dispute, is to either resolve the matter at the least cost or resolve the matter for the most benefit to them. All right, and if I can assist the parties to write their agreement themselves. So I'll write it up for them, but I basically walk them through the process, and I will only insert essential terms. All right. In arbitration, I'm also unbiased. In both instances, mediation, arbitration, I have to disclose conflicts of interest, and that's a very extensive process. As I indicated, I'm non-judgmental during the process. Ultimately, I am judgmental because I'm the one who makes the decisions. I do follow rules, statutes, and the agreement of the parties. A lot of times, the agreement of the parties, which is usually the first thing that I look at, I want to know what the parties agreed to in terms of how they're going to proceed to arbitration. And I will render an award based upon the evidence presented and the law. And I'd like to do so in a fair and undelayed manner. Okay, so let me summarize this. 1, try to resolve the dispute yourself. If you're unable to, don't delay, get help. Don't assume that you know everything. Don't assume that you know how to do anything. All right, create keystone habits and follow those habits. Control emotion and seek help from a professional. And if you can, I would read that book on atomic habits. All right. And finally, if you need to get a hold of me, my name is Howard Klein. You can find me online at howard@tkgadr.com or https://tkgadr.com, which is my website. I also do live streams, podcasts, etc. at creradio.com, which is my first online foray in podcasting. You can you can go to tkgadr.com. You can find me on LinkedIn. It's KLINE. And you could also follow me on YouTube. So, with that being said, it's a wrap, and thank you very much. You have a great day.